we're making a pitch regarding how social media companies steal your data, they get away with it, and then why that matters. Social media companies like Meta are harvesting our data without consent and leveraging it to train artificial intelligence models. We'll be initiating this case in British Columbia as it provides a more favorable jurisdiction in Ontario. BC Privacy Act offers the right to use offers users the right to sue to protect their rights against the unauthorized use of personal information. Given BC's favorable policy and the novelty of this type of class action in Canada, it's unlikely that a carriage motion will arise. This case seeks to hold social media companies accountable for such a significant breach of privacy rights. The practice of collecting user data and then using it or selling it to be used for AI model training fundamentally undermines the rights enshrined in the BC Privacy Act. These companies, given their resources and influence, should adhere to the same privacy standards required of all businesses in BC. A key precedent in this case is US v. Facebook, where the plaintiff argued that Facebook sponsored stories violated Section 3.2 of the BC Privacy Act. Facebook used users' names and images for advertising without consent. The Supreme Court affirmed that privacy rights are quasi-constitutional and tied to the dignity and autonomy of individuals, which are critical in the digital era. Our representative plaintiff is Janet Doe, a 35-year-old freelance graphic designer in BC. She uses Instagram and Facebook extensively for professional networking and promotion. Like many, Janet accepted Meta's terms of service without fully understanding their implications. She recently discovered that her creative content, photos, captions, and interactions were used to train Meta's AI algorithms without her consent. This violation mirrors the issues raised in Duas. Janet's Section 3.2 privacy rights were breached, and it exemplifies the harm caused by Meta's practices. Janet represents the average class member. She's unbiased, experienced, and committed to advocating for the class's interests. Her case exemplifies the critical need to hold corporations accountable for unauthorized data use, preserving public trust in privacy laws. The case against Meta rests on three primary legal grounds. Section 3.2 explicitly prohibits using a person's name or likeness for promotional purposes without consent. Janet's digital content was used to train AI models, violating this provision. Meta's privacy policies did not disclose the use of user data for AI training, constituting a breach of its implied service agreement terms. Users, including Janet, entered into this contract under the assumption that their data would not be used beyond the stated purposes. In Duas, the SEC recognized that failing to secure explicit consent constitutes a material misrepresentation. More recently, Tucci versus People's Trust Company underscored the need for transparency in data practices. Meta's omission of its full intentions for people's data constitutes a material misrepresentation. This case encompasses all Meta platform users in BC whose personal data, including photos, likeness, and content, was used or sold for AI training purposes without consent between October 2021 and the present. This action is about compensating individuals and upholding the integrity of privacy laws as technology evolves rapidly. We aim to deter future violations and ensure corporations like Meta respect individuals' autonomy over their data.
So now we'll be looking at the nature and extent of the damages. The damages from unauthorized data usage include lost revenue opportunities for users and the potential of psychological impact from the privacy violations. The Supreme Court of Canada has recognized that the right to privacy is a fundamental and worthy of constitutional protection, as shown in the case of R.V. Jarvis, Hunter v. Southam, and R.V. Testlinks. Because it's a case of a privacy breach, we have to look at the Privacy Act, which states two particular things to measure the extent and nature of the damages. Firstly, was it intentional conduct? In this case, yes, it was, because the company knew it was using AI tools and data to collect consumer data to help them build up their platforms. We don't necessarily need to know why they did it or if it even helped them. We just need to know that the intention was there. Secondly, was it vicarious liability? Although it is hard to prove, the simple answer is yes, because for there to be vicarious liability, all that needs to be shown is that the app or the AI software was created and used by the employer. Therefore, any potential and objective breaches that come from the result of the use of the said software made by the employer of the software in this case, defendants, makes them vicariously liable. Legal claims for breach of confidence also arise when personal information is shared confidentially and therefore they're later used and misused. Breach of privacy by an individual in a position of trust and authority may give rise to a claim of breach of confidence. The elements of this cause of actions are the plaintiff imparts information having a quality of confidence. Second, the information was imparted in circumstances in which an obligation of confidentiality arises. And lastly, the defendant makes an unauthorized use of the information to the detriment of the plaintiff. All of these apply in our case, individually and also as a collective. Now moving on to the exceptions that the defendants could potentially apply for under Section 2 of the BC Privacy Act. Section 2.2a, we believe that it wasn't consented to. However, if it was a click-wrap agreement, then the people might have consented to it. However, we cannot confirm that. Section 2.2b, it wasn't incidental to the exercise of a lawful right, as it was done purely for the benefit of the companies. Subsection C, as we know in our case, the action wasn't authorized by law or the courts. And lastly, Section 4.2, subsection 3, as we know, the other act referred to in this section was the companies taking the information and using it without the consent of the consumer from whom it was taken from. Therefore, the defendants don't apply for any of these exemptions. Now I'll move on to the strengths in terms of the certification process. So players in this industry have a history of being shady and having shady behavior. So in the case of Privacy Commissioner v. Facebook, the court ruled that Facebook violated the PIPEDA in the Cambridge Analytical scandal by failing to secure the data or observe proper user consent. Another example is the financial services firm who in a data breach resulted in 10 million customers, right? And that was only because a person within the company used the data because it wasn't protected properly. Not only is there a history, but we have to always look at the public interest to protect their rights. If corporations are shown to be in breach without exemptions as shown above, then they should be held responsible for the negligence and therefore objectively and also financially liable. There's precedent in BC of privacy violations being taken seriously. In cases of Campbell v. Capital One, the court held them liable even though it was a cyber attack, which is a much more higher threshold than in our case. So BC has a strong track record of privacy cases. Moving on to the weaknesses in terms of the certification process. The form selection clause are generally upheld by courts, but it can be argued that enforcing this clause would result in prejudice of the plaintiff. However, in the case of Area Brands v. Air Canada, the court did not certify a global class action because of the form selection clause. It can also be overruled if the significant difficulty for plaintiff to go to the new jurisdiction. There is an exemption for this under the Moloch case, which allowed the court action citing fairness and impartiality on the individual claims across the state. This is a fairly new industry with no clear aid in its regulation, as shown in the Desjardins case, which was settled for $201 million, and the Corn v. Canada case, which was settled for $17.5 million, even though there was no evidence that the information that was taken from the plaintiff was accessed.
Okay, so now we're going to talk about is this case economically viable? So this case is economically viable in our perspective for a variety of reasons. This class action would address thousands of similar cases at the same time. This is because the scope of online software is very broad and affects people across the nation. So this is especially important in BC because this would allow for access to the court to a large number of people that would otherwise not be able to participate. Because in BC, for class action law firms, they often use contingency fees, which means that they will only get paid if the case is successful, like the lawyers. So people see this as a benefit and are more likely to participate in the class action. So also data privacy is also seen as a priority by the courts and by the public. So the BC courts are more likely to consider these types of class action cases because of the importance of public support for them. And there's also a potential for a large settlement, as we saw in the Desjardins case, which was a $201 million settlement. There is also a growing number of data breach cases, which allow for more precedents for the court to analyze, which would help our case. And so these are cases like Campbell v. Capital One and the Desjardins case that we mentioned before. So now we're going to talk about law reform. So a major deficiency in the CPA is the lack of explicit provisions addressing digital privacy violations, especially in cases like Janet's where harm is difficult to quantify. The current framework emphasizes measurable financial harm, making it difficult for cases involving privacy breaches to achieve certification or achieve meaningful remedies for affected individuals. Moreover, this deficiency limits consumers' ability to hold corporations accountable for privacy violations. So this is a clear problem. So one possible provision could be to introduce a provision in the CBA that explicitly recognizes statutory damages or economic harms such as emotional distress or loss of autonomy, which would be the case in Janet's situation, as they would recognize it as sufficient grounds for certification in privacy-related cases. Okay, so now to conclude, So we hope that we have provided sufficient evidence that will lead the court to allow for certification. Certifying this case would be the right thing for the court to do and would likely result in justice being served for a large number of individuals.